Recording in progress.
Morning, Chairperson.
Morning, Sibeka. How are you?
Fine, thanks, and yourself, Chair.
Right. How's the attendance?
Chairperson, there are 6 members in the platform. Yourself,
Okay.
Honorable Khai, Honorable Mushodi, Honorable Mama Rekhani, Honorable Lond, and Honorable Dango.
Oh, brilliant. I guess we are ready to start.
Yes, Chairperson, but Ms. Ngema, she's not yet in.
Okay.
Maybe I can
you
just
will
quickly check.
indicate to us.
Let me just quickly check with them.
When they are. Yes. Morning, colleagues.
Morning, Chair.
Morning, Chairperson.
Morning, Chair.
Thank you. Allow me to welcome you to this meeting of the Select Committee on Transport, Public Service and Administration. It is a hectic week for all of us, with every day having a full agenda. I guess it's also logical to also welcome all of you. Our guest from the Department of Transport. We will also extend a word of welcome to the Office of State Law Advisor and also the Parliamentary Legal Office. Today there are 3 items in the agenda. We'll start with the CED's expropriation bill, and then the economic regulation of transport bill, the final mandates, and then we'll then deal with the minutes. The team is still working on the program for the last quarter. So those are the items that we will be dealing with. Are there any apologies that you have received, Committee Secretary?
Chairperson, the only apology is for the Parliamentary Legal Advisor, Ms. Kangen, who requested Ms. Ngema to assist her on the ERT.
Who's that?
Tiloshni Gangen.
Oh, Tiloshni, okay.
Yes.
So we are ready to start.
Yes, we are ready to start, Ms. Ngema. She's on the platform.
Okay. No, thanks. Then in that situation, let's then note the apologies, and then also then without any waste of time, give over to Advocate Tilosny to take us through the C list of the expropriation bill. Over to you.
It's Ms.
Greetings,
Phumelele.
Jefferson and the members. It will be me in both
Ah,
of
my humble and sincere apology.
them. It's okay, Jefferson. Jefferson, let me indicate up front that I had a computer crash on Monday. So I don't have my proper gadget, and therefore I will ask the assistance of the committee secretary or the content advisor to flight the C list on the expropriation bill, because I'm working on hard copies as well as my phone.
Thank you. Can we help Enrico? Or Fipela? There you are. Over to you.
Okay, Jefferson, it was a serious marathon this time. I will try what we did, Chairperson. We've had various meetings with the legal team to try and address all the concerns that were raised by the provincial mandates in terms of this bill. So what the committee has before us as flighted up, Chairperson, is the C list, which attempts to speak to the concerns that were raised. And therefore, I will try by all means to explain per clause right up until the end. Right up until the end, Chairperson, as to what we have attempted to do. Under clause 1, Chairperson, it's the clause that deals with the definitions of the expropriation bill. And therefore, there were issues raised in respect of the definition for expropriating authority, expropriation, as well as owner. In respect of that, Chairperson, and to cover extensively the communal land and customary issues that were raised, we have extended the definition and are proposing that under the definition of owner, we are going to add customary law. Then if the customary law ownership and related possessions are covered within that, it will cover all the concerns that have been raised, especially I think it was Mpumalanga or Limpopo province that their mandate was speaking to the issues of communal and rural land. That is under clause 1 and the proposal we make to cover all those concerns. Under clause 2, Chairperson, the members would recall that within the expropriating authority, back to clause 1 definition, there was a reference to section 2.3, which section 2.3 was speaking to the direct transfer of property to the third party rather than first having the acquisition of the acquisition done or taken by the expropriating authority. So what we have done in order to align the expropriating authority definition as it stands, we have inserted that 2.3 under clause 2, and then because of that insertion, there's going to be consequential amendments to correct the numbering. And what we are adding under clause 2 is an insertion that's going to read as this. This act applies with the necessary changes to the compulsory acquisition of property directly or indirectly by a third-party beneficiary through an expropriating authority in the public interest, including for the purposes contemplated in section 25(4) to 8 of the Constitution. Then once in the D version, that correction is effected, Chairperson, you will then see that there's an alignment with all the definitions as they appear, and the issues that were raised are then taken care of. And thus, as I said, the rest will be consequential amendments from number 2 right up until number 4 of clause 2. And then, Chairperson, I move to clause 5. And clause 5 is a provision that deals with investigations and the gathering of information prior to the expropriation notices and intentions are taken. So what we are correcting in clause 5 is a very minute correction, because we just wanted to make sure that instead of using relevant factors, we are using relevant circumstances as it appears in the Constitution. So we sort of ensured the alignment with the Constitution terms that are used there. And that is all in respect of clause 5. In respect of clause 7, Chairperson, and clause 7 is now the provision that deals with the notice of intention to expropriate. All the steps that will be required to be done in order to ensure that the intention is clear and it is substantial in ensuring that whoever is going to be affected by the expropriation is aware and provides whatever is required in terms of the law. So the changes that we are adding into clause 7 in light of the mandates and the proposals that came through is that, Chairperson, if you look at clause 7(2)(f) of the bill as it stands now, there was an indication that a notice of intention to expropriate must include the intended future date of expropriation, and where the expropriation is for temporary use of the property in future, the intended period of such temporary use must be part of the notice. So with the discussions that, Chairperson, we will have when we get to clause 20, which clause 20 is the one that's dealing with the agent or temporary expropriations. The issue there was raised with regards to future use and future dates and all that, whereas we explained that in terms of clause 20, it's going to be a defined, determined time that a temporary use or temporary taking cannot be beyond 12 months or an extension of 18 months. So this future date and future what is not necessary. Hence, the clause 7 amendment is taking care of removing that future reference to any word that is used for future in respect of clause 20. And that's basically the changes that will be brought by clause 7 and as proposed there. The last number 4, Chairperson, is an N. We are going to be adding an N under clause 7(2)(h) because it ends there under, it ends under 7(2)(m). We are saying, in light of the proposal, we are then saying, in addition to all the rest of the requirements that are set out, the expropriation notice must also add the details of the empowering law authorizing the intended expropriation. So every notice that will be on expropriation will also specify what is the enabling or empowering provision and the law that is seeking to give the power to expropriate, since expropriation must be done in terms of the law of general application. And so with that additional N is what we've attempted to bring as a solution to address the concerns that were raised in that regard. In respect of clause 8, Chairperson, which is now the notice to expropriate, all the details about expropriation now. In clause 8, again, the changes that we are bringing about are those related to clause 8, to the future use of the word future in respect of clause 20, and I've already explained the same. So clause 7 and 8 will be amended in an almost a similar manner, including that provision under the notice of expropriation to say again, what is the empowering legislation that authorizes the expropriation. So clause 7 and clause 8, excuse me, Chairperson, is being amended in almost similar terms with consequential amendments that will correct the drafting. Under clause 9, Chairperson, is the provision that deals with vesting and possession of the property that has already been expropriated. Again, what we are correcting there are two issues. One, in relation to the future, as well as the issue that speaks to the holder, because what we've picked up, and that's why in the end there's a general amendment that says wherever because there was about 41 places we identified where instead of saying the holder of a right, the bill is saying holder. So we will be correcting that generally in the whole bill under clause 1, should members pass the C list. So even in clause 9, we've started to point out that the holder of a right must be written in full so that it aligns with the definition section, which defines what is meant by holder of a right. So clause 9, again, to cater for all the concerns that related there, is being amended in that regard. And then furthermore, under clause 9, Chairperson, if you look at page 12 of the B bill, clause 9 2B, it read it as follows, and there was a mandate that spoke to this issue. The expropriating authority may recover any amount of depreciation caused by the willful or negligent failure of an expropriated owner of the expropriated holder to maintain the property. So there was an issue with the phrase any amount of depreciation caused. So we've tried to come up with some phrase that rather, though it conveys the same message, but we are trying to ensure that we deal with the concern that was raised. And so we have said it must rather read as follows. The expropriating authority may recover any amount, may recover the amount for the loss of value to which willful or negligent failure of an expropriated owner or expropriated holder of that property. So it seeks to just look at that issue that was raised about depreciation and how the affected person may be able to prove that. So we are now speaking to just the value that may have been lost and if they would be capable of calculating it and bringing up something, or if the expropriating authority may be in a position to indicate that value. Under clause 10, Chairperson, it was a mere correction, and because they said the provision is convoluted and confusing, we've decided to break it down and add the provisions that we felt maybe it was unclear. For instance, to indicate that if you are supposed to be providing something, who are you providing it to, in line with those unregistered rights and what is required. So clause 10, what it's seeking to do is just to clarify and make sure that there is easy reading and understanding of that clause 10.1. That's what we have done in line with the issues that were raised on the mandate in respect of clause 10. Clause 12, Chairperson, we've also considered what was raised there, and we've attempted to also engage the department to deal with the issues and the concerns as raised, like done with all the other provisions. So what we are basically doing in clause 12 is to ensure, firstly, that there is coherence with the provisions under section 25, as well as ensure that instead of, as it was pointed out, for an example, in respect of 12.1, that when we speak to the interest of the expropriated owner or expropriated holder, there may be others that we are leaving out. Hence, the change is going to be speaking to those affected as it comes from the Constitution, so that we try to ensure that it is encompassing and covering all those that need to be considered when this process and the compensation determination takes place. Yeah, I think generally that's the correction under clause 12 we've tried to bring on board, as well as the last one on page 14 in line 24 of the bill, Chairperson, which was speaking to the concerns raised in respect of that factor C, where a person may be deprived at a nil compensation if it's so decided. It was pointed out that we must make sure that despite their capabilities of having done what they can do, this must not generally be just a standalone factor that says just because they've abandoned their land, or it seems as though they've abandoned, but we must still ensure that their capabilities to have done something to try and not just abandon as it will be assumed. So we've brought in that despite being reasonably capable of doing whatever they would have done, so the expropriating authority is then put in a position to ensure that all the factors will be considered and there's a justification for them to conclude that a just and equitable compensation that is at nil is justified under these circumstances. It sort of adds another element to satisfy the process. So we've done that to align the concerns and allay what was raised by the mandates in that respect. Then, Chairperson, it is clause 13. Clause 13 is straightforward, attempting to deal with that issue of tax certificate and the claim that would have been made there in respect of interest. So what we are adding there is to provide room that the provisional tax invoice that will be presented will be provisional, so that in case there is further factors that come into the attention of the person claiming the interest, they will be able to address it and bring it back. And furthermore, I think there was an issue raised in respect of where the compensation money would be, where the compensation money, where the compensation money would be that would be put into an account. So what we are doing there is to ensure that there will be electronic transfer, as well as we thought that in other areas some people may not be able to access banking structures and infrastructure or the electronic transfers. So what we have done is to make a correction that enables the putting of the amount of compensation into various forms that can cover everybody and their circumstances. That is in respect of clause 13, Chairperson. Clause 15. Clause 15, Chairperson, on the bill is the provision that deals with the payment of compensation, whereas 13 was dealing with the payment of interest into that compensation if it is not paid on the time that it should have been paid for whatever reason. So what we have proposed in respect of clause 15 to make sure that it aligns with 25(2)(b) of the Constitution and section 34, Chairperson, we are going on at line 11, Chairperson. We are going to be removing that part that says the payment of compensation by no later than the date on which the right of possession passes to the expropriating authority in terms of section 9(2) or 4. We are going to remove that and put on a new phrase that says, on the date and in the manner as agreed to by the parties or as decided or approved by a court in terms of section 19. So should there be no agreement in terms of the previous processes, the notices and the investigations and the inbuilt counter offer processes, then what we are saying is that that compensation payment, which is not falling into any of these categories, will be done in alignment with what section 25 of the Constitution is providing. So it's another clarity and ensuring consistency with the Constitution as well, Chairperson. And then the following change under clause 15 is just consequential and necessary because of what we've done in respect of 15(1) and 2, Chairperson. Then under the third amendment, Chairperson, of clause 15, it's in line 20. After that word, when a dispute has arisen, if a dispute has risen, we are then saying, because the original provision was saying Any other dispute arising will not prevent the passing of the right to possession. What we are saying is that after the expropriating authority has decided to expropriate, and so the right to possession will not be prevented or taken at the passing of the right. It's to clarify that, Chairperson, in respect of clause 15.4.3. Under clause 19, Chairperson, it was the issue where it was indicated that we wanted to do away with the provision that is brought by the Superior Courts Act, where it's staying any movement in terms of a dispute that has been brought to court, either under appeal or review. So thus putting the expropriating authority into some inaction. So what we are providing there, and perhaps these are the two clauses that members may still need, as we pointed out, to correctly direct us. But what we have said in respect of clause 19 is to say that despite what the Superior Courts Act is providing, whatever processes are done in this regard, they will be still engaged and go on, even if there may be an appeal or a process before a court, so that when the court finally gives its decision, it will then not have stifled the process of expropriation, but would clarify how things should have been done. And then the expropriating authority will be in a position to correct whatever the court would have found to be amiss in their order or direction. But the right to eminent domain and expropriating would be going ahead without being hindered. And then, Chairperson, in respect of clause 20, this is the one where I'm going to submit that members again would need to relook at this and guide us. But what we have done is to attempt to speak to some solutions in respect of clause 20 and all the concerns that were raised related to agent expropriation. There was an issue asked whether agent expropriation is the same as temporary expropriation or the temporary use as the provisions seem to be providing. So we have engaged quite a lot on this section, Chairperson, to try and come up with some solutions. One which was in the other A list I shared with the supporting team was to say we bring about automatic review by a court in respect of the issues that would have been defined for purposes of the Disaster Management Act. We've also come up with another one, Chairperson, where we are suggesting perhaps rather in respect of that one, as there were concerns as to why we are taking away judicial intervention in respect of 22A, which is related to disaster management. We are suggesting another option that perhaps in order to not take away the provisions of the processes of following the normal expropriation processes as required and enacted or will be enacted in terms of clause 5, 6, and 7, that perhaps the minister can be enabled to make regulations to either truncate the timeframes in relation to such expropriations that are agent. But if the committee, if the chairperson may agree to allow me that maybe Advocate Uday and the department come in and explain the possibilities and what the department is hoping can be achieved in respect of this one, I would appreciate that, Chairperson, that when I'm done, you allow them to come back on clause 20 and perhaps add the clarity that I may not have done proper service to in respect of clause 20. But with clause 20, that's why I'm saying there was quite some few suggestions that we posed, but then we will be directed by the committee eventually what is the most workable one and functional for purposes of an agent expropriation and the dictates of the committee. Under clause 22, Chairperson, clause 22 is the one where it's about services and publication of documents and the language that may be used in the documents that are serviced. Chairperson, what we've done with clause 2 as well is to ensure that we include the electronic mail address as the issues were raised, that we must speak to that, and it will align with the definition of delivery where we included the Electronic Information Act and those electronic instances to correspond with the addresses. Furthermore, there was an issue, I think it was the Western Cape mandate, which raised that we need to be using English, simple English when drafting rather than continuing with the Latin terms. We have also attempted to come up with something, Chairperson, that speaks to the heirs in respect of fidei commissaries and not use that term, that Latin term. So the provision that appears, Chairperson, and was shared is what we are now suggesting, directly speaking to simple English rather than continuing the Latin terms where it can be changed otherwise. And the rest then, Chairperson, will be consequential changes. And then in line 59, which is in respect of the delivery contemplated under subsection 3, we are adding, as already pointed out in sub 1, that electronic mail, as was asked for, will also be used, and in any other manner which may be prescribed by the minister to cater for all the evolving things that AI and whatever electronic means of communication are coming about. Hence, we are putting that enabling provision under subsection E. So under 4, there's going to be an added D and E that speaks to the concerns that were raised. And then under clause 27, Chairperson, as I'm winding towards conclusion, 27 is a provision that deals with regulations. And so there we are just adding the term of interest for all those that would be having interest in dealing with this provision. It's a consequential amendment, Chairperson, after reading what the mandates were indicating. And then the last one, Chairperson, on general amendment is the one that I already spoke to align holder of a right definition with wherever holder or expropriated holder is appearing in the bill. It must be corrected so that there is congruency and proper understanding and reading when anyone reads the bill in its entirety. So this is the C list we have prepared, Chairperson, in light of the proposed negotiating mandates and their proposals. And I am going to end there and ask that Chairperson allows the department and Advocate Naidu to speak to clause 20 just to bring final clarity there before members can pose their questions. I thank you, Chair.
Thank you, Advocate Ngema, for taking us through the C list. As you have indicated, let's give the other team, the state law advisor and also the department, just to amplify clause 20 as you have requested, and then thereafter we'll then give over to the members. Let's give first the department.
Morning, Chair. Masilo Marke, DDG. Our legal counsel, Advocate Naidu, will give the clarifications required. Thank you very much. Over to Advocate. Thank you.
Thank you, Mr. Marke. Advocate.
Thank you, Chairperson and members of the committee. I'm going to share my screen if that's possible, so that we can all follow the language of clause 20. May I ask the host, please, to give me permission to share?
Rebecca, can we have the advocate?
Thank you. Thank you, Chairperson. This is clause 20 on screen. I wonder whether the Chairperson is able to see it.
Yes, we can see clause 20.
Thank you. Chairperson, I'm going to start with the problem statement before detailing the department's proposal. Clause 20, as we all know, deals with expropriations in urgent circumstances. Those expropriations do not follow the ordinary path which non-urgent expropriations do. Clause 23 exempts an expropriating authority from complying with clause 5, 6, and 7 of the bill when expropriating urgently. Clause 5, as the committee will recall, deals with the investigation stage on the suitability of the property for the intended purpose. Clause 6 deals with the engagements between the expropriating authority and the municipality. Clause 7 deals with the notice of intention to expropriate and the expropriating authority's invitation to owners or holders to make representations about the expropriation or the amount of compensation or both. The current formulation of clause 20 simply requires an expropriating authority to take the property if it deems the property to be necessary for a public purpose or in the public interest. It does not require a prior investigation, prior engagement with the municipality, or prior engagements with the owner or holder. This, the bill attempted to balance out by requiring an expropriating authority to get a court order to expropriate urgently where there are exceptional circumstances or where there's a real and imminent danger to life or damage to property or any other ground that the court considers appropriate. After this section was formulated, an insertion was made in the form of paragraph A. The insertion was to account for urgent expropriations where a state of disaster had been declared under the Disaster Management Act. That section, of course, does not require a prior court order to expropriate urgently. And this has created a disjuncture on the face of it between paragraph A and paragraph B. That was the problem which vexed this committee. The legal team in the department thought about this and engaged with the parliamentary legal advisor and the state law advisor. We had a further round of internal consultations, and those consultations lasted up to this morning, in fact. The department was concerned that requiring a court to give its blessing to an intended expropriation where a state of disaster has been declared, or even to have court review after the expropriation has occurred under a state of disaster, might be over-judicializing the process. The department was also concerned that exempting an expropriating authority from the duty to conduct a proper investigation as to the suitability of the property and to take on board representations from the owner or holder who would be affected by an expropriation might compromise the non-arbitrariness requirement for every deprivation of property in terms of Section 25(1) of the Constitution. The committee will be familiar from the opinion that I furnished that every deprivation of property under the Constitution must be non-arbitrary to pass constitutional muster. That means there needs to be procedural protections and substantive protections. Both must be rational, substantively non-arbitrary and procedurally non-arbitrary. If the views of affected persons are not to be taken into account at all for an urgent expropriation, the department questions whether those expropriations will pass the non-arbitrariness test. So instead of exempting the expropriating authority from the requirements of clauses 5, 6, and 7, and inserting a court as a mediator, the department's proposal is to require the expropriating authority to comply with the investigation and consultation requirements in clauses 5, 6, and 7, but to do so on a truncated timetable, so that the benefits of consultation are not foregone altogether. The proposal is to reframe clause 23 to state the minister must make regulations to shorten the timeframes contemplated in sections 5, 6, and 7 to account for urgent expropriations. That formulation would mean that an expropriating authority still must do its homework to determine the suitability of the property for the intended purpose, to engage with the municipality on outstanding rates and zoning requirements and so on, and importantly, to give prior notification to an owner or holder who stands to lose their property of the intended expropriation and to elicit comments from them before actually taking the property, but to do so in a more streamlined, truncated way, more quickly, essentially. And that, we think, would probably guarantee that the deprivation would be substantively and procedurally non-arbitrary. It would also mean that the committee would not need to bring into the frame a court when dealing with urgent expropriations under a state of disaster. Of course, the bill currently provides for a court order in circumstances where property is needed urgently under exceptional circumstances and where there's a real and imminent danger to human life or potential destruction to property. But those circumstances are outside the context of a state of disaster. Further, the committee will also be aware that if an expropriating authority has taken property for temporary use and wants to extend the duration of temporary use beyond 12 months, it needs a court order for that purpose. That's the import of clause 27 and 28. The department's view is that court oversight might not, strictly speaking, be necessary for that purpose if the expropriating authority is required to comply with clauses 5, 6, and 7, albeit on a truncated time frame. But removing court oversight at this point in the bill's history might entail another round of public consultation, which the committee might not want. So the department's core proposal is that clause 23 be amended to dispense with the exemption provision and to replace it with one requiring the minister to make regulations simply to truncate the time periods for investigation and consultation under clauses 5, 6, and 7. And if the committee is so minded, to reconsider whether a court needs to grant an order before an expropriation can take place in urgent circumstances where a state of disaster has not been declared for the purposes of 22B and for extensions potentially for extensions under 7 and sub 8. Chairperson, I wonder whether you might have the committee might have any questions with which I could assist them with.
Yes, let's test that, advocate. Members, is there any clarity in questions from the advocate in relation to elaboration around clause 20? Particularly doing away with the exemption. Can I, maybe from my side, advocate the doing away with the exemption. That's because our country is a constitutional democracy. The understanding is that any decisions taken by the expropriating authority will have to comply with both Section 1 and Section 2 of the Constitution. There's the supremacy of the Constitution, but I think more than that is the issue around the values that are enshrined in our Constitution, particularly the rule of law, the issue of accountability, the issue of transparency, the issue of rationality. Those are the values that necessarily the expectation is that any decision taken by an administrative body, there has to be a rational connection between the decision taken and the facts at hand, meaning that the decision must not be irrational. And the Constitution further affirms the court the constitutional right to be able to review such decisions that are considered to be unconstitutional. So the understanding is that whether the exemption is there or not, the rule of law is sacrosanct and will also apply, or the Constitution will also apply to the expropriating authority, meaning that the decision taken by the expropriating authority in relation to the decision to expropriate must be constitutional. It must be transparent. It must be rational. Within that context, the point that I'm making is that any attempt to do away with the court, because it's discretionary. The court has a discretion in terms of the Constitution to be able to review decisions that are not in line with our Constitution. Within that context, what does this mean in relation to clause 20? The attempt to remove the exemption, because you can't exempt any whether it's a legislative authority or executive authority to dispense with the power of the courts, because it is enshrined in the Constitution. If you take a decision that is not constitutional, the court has the discretionary power to review that decision.
Yes.
Yes, over to you, Advocate.
Thank you, Chairperson. I agree with you that courts have the inherent discretion to review the exercises of all public power, including administrative decisions. What clause 22B does, however, is requires the court to make a decision even before the administrator decides to expropriate the property, in order for the administrator to expropriate the property. That's a very different sequencing of events from permitting an administrative authority to take the decision and then to allow someone to challenge that decision on judicial review. Currently, that's what the bill provides for outside the context of states of disaster. Whether the committee wants to change that, I think is a question that, with respect, you'll have to grapple with. There's another part of what you've asked me, Chairperson, which I think I do need to address. If I understand the question correctly, the proposition seems to be that it might not be necessary to do away with the exemption because an administrator would in any event need to comply with the values of the Constitution and the rule of law. I may be mistaken in that understanding, but if that's correct, then my view would be, my submission would be that although that is true, it's the function of the legislature to provide an appropriate level of guidance to an administrator so that the administrator has legislative variables that guide how it exercises its discretionary power to expropriate. At the moment, in the context of a disaster, a national or provincial or municipal state of disaster, Clause 22A provides no variables at all. It simply says if the property is required under a national state of disaster, the expropriating authority may take without needing to satisfy itself of any of the conditions in Clause 5, without having to engage with the municipality under Clause 6, and without having to engage with an owner or holder under Clause 7. The department's reservations about that are, it may be that if that expropriation is taken on judicial review, a court might find that failure to engage and to consider those factors spelled out in Clause 5 might render the expropriation arbitrary and therefore invalid. And that's something that the bill should avoid by providing appropriate guidance. And we think the appropriate guidance already exists in Clauses 5, 6, and 7, and therefore there's no need to exempt an expropriating authority when a state of disaster has been declared and in urgent circumstances from complying with 5, 6, and 7. But the department does think that in order for expropriations to occur urgently, where there's a need for that under a state of disaster, the time periods for complying with clauses 5, 6, and 7 do need to be truncated. And it would be difficult for Parliament to say exactly how they should be truncated in all circumstances, because of course there are degrees of urgency. And so the department thinks that's best left up to the minister to determine in regulations. If Parliament is going to give the minister that option, it should require the minister to do so, specifically for the purpose of catering for urgent expropriations. That would comply with the Constitutional Court's dictum in Dawood, which the committee will know from the opinion that I furnished. It's really all about appropriate legislative guidance for administrative functionaries to exercise their discretionary powers. Chairperson, if there are any other questions?
Yes, looks like members are quite clear in terms of the explanation that you have given. I'm also on board. Understand the context within which the department comes from. Obviously, to avoid the issue of affirmment around the court overreaching, I think it does make sense to have guidance regulated, and that in itself, therefore, then it is able to give guidance in terms of what must happen, not leaving it absolutely not attended to. Well, thank you, Advocate. Is there any other?
Chairperson, forgive me, if I may, we have debated this internally within the department, but we have not had time to consult with the state law advisor or the parliamentary legal advisor on this, on the substance of these proposals. Chairperson, we would ask with great respect for an opportunity to do so, in order that the parliamentary legal advisor and state law advisor might craft appropriate language for the committee to consider.
Okay. No, I think it makes sense. Let's then have a matter to do. We will give guidance in relation to that. Is the state law advisor on the platform, Committee Secretary?
Thank you, Chairperson. May I be excused?
Thank you, Advocate.
Thank you.
Yes, Chair, I am present.
Yes, the floor is yours. Let's hear what the office says in relation to clause 20.
Chair, I'm not opposed to the proposal, but as the advocate indicated that we do probably need to consult a little bit more on the proposals, because this proposed amendment is actually brand new. I mean, they just proposed it now this morning, about a few minutes before the meeting started. So I don't really have anything further to add to that, Chair. Thank you. We'll be guided by the committee, of course, whatever resolution that the committee might take in that regard. Thank you, Chair.
Thank you, Advocate. Umbrella on that. Let's get Committee Secretary. In terms of because this is still what does this mean in terms of our program?
Chairperson, because of the request by the state law advisor and the department that there should be a further consultation on clause 20, then it means we
cannot adopt the C list.
Yeah, we cannot adopt the C list, but I also want Ms. Pumelele also to talk about this before the committee decide, but we cannot proceed with the C list, with the adoption of the C list, because it's not final.
Okay. Yes. Advocate Pumelele.
Thank you, Chairperson. Chairperson, I think, yes, we do need to be guided by the committee in respect of that. And if we can then be given a chance to relook and add on the C list clause 20, as I said, because what we provided initially is different from what is suggested now, as it will rather be addressed in the regulations as opposed to what we suggested. So perhaps the committee, I'm not sure of the program as to how it was planned, as we would still need to incorporate that change and then have a diversion in terms of the final mandate, and considering the time frames of the House as well as this committee, we will be guided, Chairperson, but if we need be, we will have to try our best to work under very pressurized time to ensure that we bring this, because we've already tried to find our minds on it and spoken on it. It is just for us to find the proper wording and ensure that it complies with the drafting standards, Chairperson. So we will need time just for that, and then we can handle it with the direction of the committee. Thank you, Chair.
Thank you, Gemma. Other members? Honorable Dango.
Thank you, Chairperson. Chairperson, having listened to the legal advisors, all three of them, I think we need to find in the programming committee a space for them to come back so we can adopt this. Otherwise, we would be passing law that may not pass constitutional muster. Thank you.
Thank you, Ambassador. Yeah, we will definitely then, because I see there's also a hand. Okay, this Honorable High, can you come in?
Thanks very much, Chair. Chair, I just wanted to perhaps find out from the legal advisor as to how long this process could take, and if it could be maybe a week, and see whether we cannot then apply for a special committee meeting to consider the new proposed clause, so that we can then send and we can then adopt the seat list in the special meeting, so that we are able now to send the seat list to, in fact, the integrated bill to the provinces for the conferral of the final mandate.
Final mandate, yes.
Rather than to wait for when we come back in February next year. So I just wanted to check that. Thank you so much.
Thank you, Honorable Kai. Mr. Nyama?
Thank you, Chairperson. I think a day can do, Chairperson, because it's merely just clause 1, and we can just make time to tomorrow and yeah, be done. A day would be sufficient.
Right. Mr. Masike?
Chairperson, I have my hand up.
Okay. Honorable Pratusa?
Chairperson, thank you. And I just want to commend the committee on being, my apologies, Chairperson. I just want to commend the committee on being I'm searching for the right word, Chairperson. Just being diligent in making sure that we have all our ducks in a row, that everything is done correctly. Chairperson, I'm advised by my colleagues in KZN legislature that they pretty much are closing up this week. So I don't know whether if we and I agree with Honorable Khai that maybe a special meeting might be useful, but I'm not entirely sure that even if we do that, that the legislatures will in fact be open after this week to actually consider whatever we send to them. So I think that if we move at speed now, it may end up having exactly the same effect later. So just want to put that into the think tank. I just wanted to put that out there, Chairperson. But I do just want to thank the committee for being sensible about considering all aspects before we send it back to the provinces. Thank you, Chairperson.
Thank you, Honorable Professor, for the comment in terms of the diligence that we are doing. I guess, like as Advocate Ngama has indicated, a day is necessary, will allow them to be able to finish. Today is Wednesday. I guess we will need. Let's allow them to meet today, and then the committee secretary will then give us guidance towards the end of the day or early tomorrow, whether that final consultation is done. If that happens, if they can manage to do it today, then we can either even between 8 and 9 Friday adopt the C list, and then we know that once that is done, of course, take into account the point that that is raised by Honorable Pratusa, then we'll be able then to finally disclose the matter. but like as already pointed out, let's get guidance from the team, but we do that within the context that if tomorrow or by the end of the day they are able to find each other, then we'll definitely then request the office of the chief whip and the house chairperson to program to slot us, because we'll just need an hour part of the list. Is that correct, other members? Can we close it on that note?
Chairperson, I think is okay. We
Thank
agree.
you. Thank you, other members. As then,
Chairperson, I don't know if you can't see the hands.
my humble and sincere apology, Honorable Land.
No worries. Chairperson, I do appreciate that we're under time pressure, but I've raised this before. We schedule our meetings not just a day or two in advance. So the entire week of mine is booked. My diary is full. To now say I need to clear meetings that I've already set for Friday morning, it's not really reasonable. And I would ask you to please be cognizant of the fact that we have many other responsibilities that we need to juggle, and to now at last minute put something in that is going to remove some members from participating is not really fair to do on such short notice.
No, we take that into consideration, Honorable Lund. We'll definitely in our approach to the House Chair and also the Chief Whip take that into account. Thank you for raising that. Thank you, members. Let's then close this
Chairperson.
Yes.
So, Chairperson, I believe maybe you can't see the hands, Chairperson. Chairperson,
I can
also,
only see the hand of Honorable Boshoff now.
yeah, Chairperson, sorry, my hand was up. Just also to let you know that there's actually a meeting scheduled tomorrow morning between 8 and 9 for the Joint Standing Committee for the Financial Management of Parliament, which also affects Honourable Khai. So tomorrow morning is already a bit jammed, and also myself, I'm actually on a flight back to KZN tomorrow morning at 7 o'clock. So I won't be able to attend that meeting or any meeting that you might want to schedule for this committee. So if you do proceed, please note my apologies for tomorrow morning. But as I say, as Honourable Lon says, you know, we seem to have a really hectic schedule at the moment, so it might be difficult to do tomorrow morning. Thank you, Chairperson.
Thank you, Honourable Team. Honourable Suanya Boshoff.
Thank you, Chair. I just want to reiterate what both Honourable Lund and Brate have said. Tomorrow is definitely out for me as well, and in the coming weeks as well. So please just note that, and it makes the process unfair if the DA is not able to attend these crucial meetings. Thank you.
Thank you, Honourable Boshoff. Honourable Khai.
Yeah, in view of the comments by the honourable members, Chair, I want to perhaps suggest that perhaps anyway the legislatures might not do anything about the list, even if we send it this week. I would rather propose that then maybe the first week of February. You remember yesterday we said the sister committee will be having a meeting on the 6th. Maybe then on the 2nd we could have a meeting to consider the list, and thereafter we send it to the provinces. I would like to propose
Thank you, Honourable Khai. I think that's reasonable. Members, that's the concrete proposal from Honourable Khai. Let's see.
But then the legal advisor and the department can perhaps continue as soon as possible, and then maybe send those particular clauses to members of the committee as soon as possible, so that by the time we consider the list, we would have seen the relevant changes that have been proposed. Thanks.
Thank you, Honorable Khai. Honorable Dango?
Second, Honorable Khai's proposal, sir.
Thank you. Can we then, of course, impress upon the Advocate Ngema, Brother, and also Mr. Masiki and Advocate Naidu to make sure that before the end of this week, this matter is sorted out, so that when we meet in February, at least we know that when we rise, your consultative process is exhausted. But of course, I think concrete proposal will then definitely deal with the matter in February. Thank you, honorable members. Let's close the matter on that note. Let's then go to, of course, take this opportunity to excuse the team that has been helpful to us on the expropriation bill on the C list, because we are now proceeding to the ERT. Will be guided by the secretary. Committee Secretary?
Thank you, Chairperson.
On the ERT now, the final mandate.
Yes, Chairperson, you are correct. The next agenda item is the final mandate on the ERT bill. Chairperson, maybe before we proceed, I want to put to the House, to the committee, as I indicated to you, Chairperson, that we've been working with the legal team, both from the State Law Advisor, the department, and the parliamentary legal team, on the finalization of the final bill in terms of the corrections. So as we speak, Chairperson, the team is satisfied that all the corrections were attended to, and we have sent, that request to the service provider, which is CREDA, to issue us, the final bill. So this is what it is I wanted to put before the committee through you, Chairperson, before we proceed.
Thank you. I think on that note, let's then allow the presentation of the final mandates. Is that an old hand, Honorable Dango?
Old hand.
Thank you, Ambassador. Thank you, Committee Secretary, for taking that aspect and then bring it to our attention. Let's then allow the provinces to then give us the final mandate. We will ask just probably from the content advisor. Let's start first with Eastern Cape. Dr. Clark, let's start first with Eastern Cape.
Yes, thank you, Honourable Chairperson. I will open in a moment.
Thank you.
Is my screen visible, Honourable Chair?
Yes, it is visible. Honourable Khai, we're dealing with the Economic Regulation of Transport Bill, number B1D of 2020. Over to you, Honourable Khai.
Thank you very much, Honourable Chairperson. The final mandate on economic regulation of transport bill to the Chairperson of the National Council of Provinces. The name of the bill is the Economic Regulation of Transport Bill. And number of the bill B1D-2020. The date of deliberation was on the 4th of December 2023. The vote of the legislature. The provincial legislature votes in favor of the bill and mandates the Eastern Cape permanent delegate to the NCOP to vote in favor of this bill. Regards Honorable Helen Sauls August, MPL, Speaker of the Eastern Cape Legislature. Thank you, Chair.
Thank you, Honorable High. Let's then move to Free State. Honorable Mashodi.
Thank you very much, Honorable Chairperson. Free State Legislature, final voting mandate to the Chairperson of the National Council of Provinces, the name of the bill, Economic Regulation of Transport Bill, number of the bill, B1D-2020, date of deliberation, the 5 December 2023, vote of the legislature, Honorable Chairperson, the Free State Legislature vote in favor of the bill, signed by the Speaker of Free State Legislature, Honorable N.B. Sifuba, on the 5 December 2023. I thank you, Chairperson.
Thank you, Honorable Mashodi. Out there, Honorable Dango.
Chairperson, thank you very much. The Office of the Speaker, final voting mandate to the Chairperson of the National Council of Provinces, the Honorable A. Masondo. Name of the bill, Economic Regulation of Transport Bill, number of bill, B1D-2020. Date of deliberation, 5th of December 2023. Vote of the legislature. The Gauteng Provincial Legislature supports the principle and the detail of the bill and therefore votes in favor of the bill. Economic Regulation of Transport Bill, signed by the Honorable Merkwe, Speaker of the Gauteng Provincial Legislature, dated 5th of December 2023. I thank you.
Thank you, Honorable Dango, Ambassador, for presenting the mandate of Gauteng Legislature. KwaZulu Natal, Honorable Brataseth.
Yes, Chairperson, my apologies. The final mandate for KwaZulu Natal to the Chairperson of the NCAP, name of the bill, Economic Regulation of Transport Bill, number of the bill, B1D-2020, date of deliberation, Tuesday, 5 December 2023. Vote of the legislature. The KwaZulu Natal legislature met today, Tuesday, 5th of December 2023, and agreed to mandate the KwaZulu Natal delegation to the National Council of Provinces to support the Economic Regulation of Transport Bill, B1D-2020, signed by the Speaker, Honourable Boyce, date 5th December 2023. Thank you, Chairperson.
Thank you, Honorable Brataseth, for that, presenting the KwaZulu Natal mandate. Limpopo, Honorable Marakhani. Honorable Marakhani. To the Chairperson of the National Council of Province, the name of the bill, the Economic Regulation of Transport Bill, the number of the bill, B1D of 2020, the date of deliberation, the 1st of December 2023. The vote of the legislature of the province, vote in favor of the bill, signed by the Honorable Speaker Molapo on behalf of the Limpopo Provincial Legislature. Thank you, honorable members. Mpumalanga. Honorable Boshoff.
Can they flight it, please? Ah, there it is. No, there's no flighting of it yet.
Chairperson, I think this is the report. Maybe Dr. Clark flight the correct bill.
Yes, let me just pull up the mandate.
There you are, Honorable Bishop.
All right. Let's see if I can move it because I'm on my phone. Okay, final mandate to the chairperson of the NCOP, Honorable N.A. Masondo, name of bill, the Economic Regulation of Transport Bill, number of the bill be 1B/2020, date of deliberation 4 December 2023, vote of the legislature. The delegation representing the province of Mpumalanga and the National Council of Provinces is hereby conferred with a mandate to vote in favor of the bill. Duly signed on the 4th of December 2023 by Honorable MC Masalela, the Speaker of the Mpumalanga Provincial Legislature. Thank you.
Thank you, Honorable Bishop, for presenting the mandate of the province of Mpumalanga. Northern Cape.
Northwest, Chair.
And Northwest is after Northern Cape, Honorable Landsman.
Okay, Chair.
Thank you. The name of the bill is the Economic Regulation of Transport Bill, number B1D of 2020. The number of the bill, B1D of 2020. The date of deliberation took place on the 5th of December 2023. The vote of the legislature. The committee supports the Economic Regulation of Transport Bill, signed by the Honorable Speaker of the Northern Cape Provincial Legislature, Honorable Cluster. Thank you. Northwest. Honorable Landsman.
Thank you, Chair. Office of the Speaker, final mandate. To Honorable Masondo, Chairperson of the National Council of Provinces. Name of bill, Economic Regulation of Transport Bill. Number of bill, B1D 2020. Date of deliberation 5 December 2023. The Northwest Legislature vote in favor of the Economic Regulation Bill B1D 2020. In case of being no changes on the bill during the discussions of the final mandate, the Select Committee, the final mandate shall be constituted a voting mandate. Signed by the Honorable Speakers, BRS Susan Dainchi, Speaker, on the date of the 1st 12/2023. Thank you.
Thank you, Honorable Landsman, for presenting the mandate from the province. Western Cape, Honorable Lord.
Dankie, voorsitter. Final mandate addressed to Honorable Masondo, the chairperson of the NCOP. The name is the Economic Regulation of Transport Bill. The number of the bill is B1D 2020. The date the province deliberated on it, 4th of December 2023. And the vote of the legislature is as follows. The Western Cape Provincial Parliament confers on the Western Cape's delegation in the National Council of Provinces the authority not to support the bill. Thank you.
Thank you, Honorable Lord, for presenting the mandate from the province of the Western Cape Provincial Legislature. Committee Secretary.
Thank you, Chairperson. We have now come to the item of the report. We are placing the report to the committee so members can vote on this report. I will read the report to the committee. Draft committee report, a report of the Select Committee on Transport, Public Service and Administration, Public Works and Infrastructure on the Economic Regulation of Transport, B1B 2020, National Assembly, Section 76, dated 6 December. Introduction. The bill was passed by the National Assembly, transmitted to the NCOP for concurrence, and referred to the Select Committee on the 27th September 2022. The Economic Regulation of Transport Bill, B1B 2020, Section 76, inverted commas, the bill seeks to consolidate the economic regulation of transport within a single framework and policy, to establish the Transport Economic Regulator, to establish the Transport Economic Council, to make consequential amendments to various other acts, to provide for related incidental matters. The select committee process followed in respect of the bill. The Department of Transport briefed the committee on the bill on 8 February 2023. On 26 March 2023, an advert was placed in the national media calling for written submissions on the bill with deadline of 24 April 2023. The committee had oral submission on the bill on 7 June 2023 and 6 and 20 September 2023, and the department addressed the committee on its response on oral written submissions on the bill. On 8 November 2023 and 22 November 2023, the select committee considered the negotiating mandates on the bill as received from the provinces, and on 29 November adopted the series agreed amendments to the bill. 9 provinces submitted final mandates on the bill, which were considered on the 6th of December. The mandates were submitted as follows. I won't go through the mandates because the mandate has already been read. Number 3, the outcome of the select committee's consideration of the bill. The select committee on transport, public service and administration, public works and infrastructure, having deliberated on and considered the subject of the economic regulation of transport bill B1B 2020, National Assembly referred to it as classified by the JTM as Section 76 bill, report that the bill has agreed amendment bill B1D 2020, report to be considered. Chairperson, that is the report.
Thank you, Committee Secretary, for presenting the committee report on the economic regulation of transport before the committee. Are members any reflection on the report that members would want to raise? Can I now, in the absence of that, put the report to the committee members? Those that are voting in favor of the report, of the adoption of the report, can they do so by raising their hand, using the raise your hand option on your gadget? Committee Secretary?
Thank you, Chairperson. Those who are voting in favor are as follows. I won't read them in alphabetical order, but the way they are in the platform is Ms. Mushodi, Honorable Mushodi, Honorable Khai, Honorable Mama Rekhani, Honorable Dango, yourself, Chairperson, and Honorable Landsman. The numbers are 1, 2, 3, 4, 5, 6, Chairperson.
Thank you, Committee Secretary, for that. Can members take down their hands? Can we then invite those that are voting against to raise their hands? Those that are voting against, can we, Committee Secretary?
Chairperson, I don't see any hand.
Thank you. Those that are abstaining? Committee Secretary.
Chairperson, the abstentions, it's Honorable Bratathes, Honorable Lund, and Honorable Boshoff.
Thank you. Can you then give us the final results?
Chairperson, the report has been supported by more than 6 members, which means that in terms of the rules, the report chairperson can be sent to the House. And those who abstain, those who are against, none, and those who abstain are 3. Thank you, Chairperson.
Thank you, Committee Secretary. Honorable members, can you take down your hand? Thank you, members. The report is duly adopted by the Select Committee on Transport and Public Service Administration, and it will be recommended to the House for adoption as per the overwhelming support of the committee members. And therefore, we are actually recommending the report to the House on the adoption of the economic transport regulation. Thank you, honorable members. The next item on the agenda.
Chairperson, the next item on the agenda is minutes. I will request Enrico to flag 3 sets
Can
of
we
minutes.
then probably those guests of ours that were with us right at the beginning take this opportunity to express our heartfelt gratitude to them for being part of us. They are free to excuse us now as we now deal with internal matters. Thank you, our guest. Yes, Andrew Subega. The minutes of the 22nd of November, it was the negotiating mandate on the National Land Transport Amendment Bill and the National Road Traffic Amendment Bill. This meeting was held on the 22nd of November. Those are the attendees. Members can pay attention so that there's no one that attended this meeting of the 22nd of November that is left out. Can we then go to our guest? We have then the committee staff, the parliamentary staff. That is the opening remarks that was made. And then the apologies were noted. And then the National Land Transport, that is the reflection of how the provinces voted. And then the National Road Traffic Amendment, also summary of the negotiating mandates on the National Road Traffic Amendment Bill. That's how the provinces voted. Those are the then the economic regulation of transport. Those are the reflections that were made, presentation, and then the meeting was adjourned. Is there any correction that members might have picked up as we were going through the minutes? In the absence of that, can I get a mover for the adoption of the minutes of the 22nd of November? It's a reflection. Thank you, Honorable High moves, seconded by Honorable Dango. Anyone that is opposed for us adopting the minutes? None. Therefore, the minutes of the 22nd of November is duly adopted. Next set of minutes.
November, Enrico.
Members, those are the minutes of the 24th of November of the Select Committee on Transport, Public Service and Administration, Public Works and Infrastructure. They were dealing with the negotiating mandate on the expropriation bill. The attendance by Select Committee members is reflected. Then the guests that were in attendance is also covered. Followed by the parliamentary support team, and then the open remarks, and then we noted the apologies, and then in terms of how the meeting unfolded, it was the reflection as to how, in terms of the mandates, the negotiating mandates, provinces reflected on how they voted. And then does the committee, and then we then reflected. You can see the last paragraph thereof. I'm just trying to capture that. Any correction that members would want to register in terms of the minutes before us? And in the absence of that, can we then have a move of the adoption of the minutes?
I move, Chair.
Thank you, Honorable Landsman, for moving. Can you get a seconder?
I second Honorable Mushodi. Thank you very much, Chair.
Thank you, Honorable Mushodi. Therefore, the minutes of the 24th of November is duly adopted. Can we then move to the next set? The next set. The next set of minutes is the one of the 29th of November, where we're dealing with the negotiating mandates on the C list of the economic regulation of transport, and also the final mandate of the National Road Traffic Amendment Bill and the National Land Transport Amendment Bill. Those are the committee members. Then the guest in attendance, and then the committee staff. That's a reflection of the task for the day. And can we go up? Yeah. That's how the meeting unfolded, members. We had some reflection by our esteemed lawyers that were present amongst us. And then the proceedings as to how provinces voted. Still on the National Land Transport Amendment Bill. You can see how provinces voted. Then the meeting was adjourned. Are there any correction, members? Can you then get a mover for the adoption of the minutes? So it's a true reflection. A mover.
Move, Chair.
Thank you, Honorable Khai, for moving. Can we get a seconder?
I second, Chair.
Thank you, Honorable Dango. So, anyone that is against? The absence of that for the minutes actually adopted. Committee Secretary?
Thank you, Chairperson. I think we have exhausted, the agenda of the day.
Thank you, Committee Secretary. Honorable members, it looks like we were able to sufficiently deal with the items before us for the day. Allow me to take this opportunity to express a word of gratitude to all of you. It has been a hectic term for all of us, a hectic year for all of us. I believe this is the last meeting for the year, and it is only proper that we take this opportunity to wish these esteemed members of the Select Committee, our guests, and also our staff a happy Christmas, a safe holiday, and ensure that you are able to rest and come back next year recharged, re-engineered, and also ready to ensure that we prepare ourselves to the last lap of the sixth administration, while at the same time, all of us, particularly those that comes from various political parties, will be crisscrossing their provinces, their villages, their townships, their towns to lobby our communities to exercise their right to vote. And we hope that as we prepare for that, we will come back, all of us healthy. And let's then formally adjourn this meeting. We know that this week is hectic for us committee members. Let's meet in the plenary 2 o'clock. Therefore, the meeting is adjourned. Thank you.
Thank you, Chair. All the best for Christmas.
Thank you so much.
Yeah. Thank you, Chair. Thank you, honorable members.
Thank you.
Thank you.
Thank you, Chairperson. We'll talk in the House.
Thank you.